Hey, good afternoon, everybody. John here, and we are officially in week 3, believe it or not. So, first 2 weeks have been great. I've appreciated all the great engagement. Um, the first 2 weeks, last week, especially as we talk about the standard of care, and some of the things that I'm going to talk about today is just going to reiterate um, some things that I've said in the past, and there's a reason for that. And the reason is because it's very important, and especially as you dive into the milestone projects, especially the milestone project for the iTeraldi case. Um, some of these things are really important to keep in mind uh, as you're completing that. So, this past week, the discussion question, there wasn't a written assignment, but the discussion question really got us thinking about the standard of care. And standard of care is important, but I want you to remember that it is only one element, one of 4 elements in a medical negligence case. And remember, I think I mentioned this maybe the first week. My sophomore year of college, physics professor would always talk about how easy physics was. Not for me, but obviously for him. Um, but the reason he said that was he said, look, all the formulas are here for you. All you have to do is put in the numbers, turn the crank, and you come out with your answer. And I totally get it. That's, for me, that was not easy with physics, and obviously legal analysis is something I do every day, so that's a little bit easier for me. But it's the same concept, and I want you to think about it like that. So when you're doing a legal analysis, when you're looking at the first milestone case for the iTeraldi, first milestone project for the iTeraldi case, think about the legal component section in this way. So your one major legal component that and I don't think I'm giving anything away here, is that we'll be analyzing is medical negligence, and particularly Dr. Ricketson's medical negligence. And remember that we're not talking about negligence like, oh, I left the garage door open last night, sort of negligence, or I made a mistake here or there. This is legal negligence, it's a legal term of art, meaning it has 4 elements. It's comprised of 4 elements. If one of those elements is missing, that there is no negligence. It doesn't exist in the legal sense. And so no matter how bad Dr. Ricketson messed up, if the other 3 elements, if all 4 elements don't exist in the case, then there's no legal liability. There's no legal negligence. And so at least there's no legal liability when it comes to negligence, if that makes sense. So remember the 4 elements. I think your text refers to them as the 4 Ds. The first one is the duty. And remember, we're working through that IRAC method of legal analysis. We state the issue, what is the rule, apply the specific facts. This is why that first case description project was so important. It really required you to look through specific facts in the case and outline those. Apply specific facts to the rule, and then come out with your conclusion. And if your analysis is reasonable, your conclusion will be reasonable, and that's all that matters. And we're not here about right or wrong answers. We're here about analysis. So for medical negligence, if I'm analyzing that, first element, duty. What's the rule? Well, the rule is that a duty is created when that physician-patient relationship is formed. Okay, what facts in the case are applicable to that rule? So apply those facts to that rule, and then do your analysis and come out with your conclusion. Second element, deviation from the standard of care, a breach of that duty. I think your text refers to it as dereliction. So it's all the same thing. So what's the rule? Apply facts to that rule, come out with your conclusion. Next, causation, and then finally damages or harm. So that's really important. Remember, standard of care is one of 4 elements that need to be analyzed in that sort of situation. This week we're talking a lot about risk, and I really like talking about risk because it's the predominant way that I provide legal guidance in with my healthcare clients. Sometimes there is a right or wrong answer. Sometimes the law is clear on what maybe a client or a healthcare provider wants to do, but that's sort of the anomaly. I mean, most of the times, most times it's you can make an argument one way or another. It's sort of in that gray area, and so that's where the legal guidance and legal analysis comes into play. And so the way I typically approach that is in terms of risk. Well, here are three options how to approach the situation. Each option carries with it a certain level of risk. This is the high risk option, medium, low risk option, and that really helps the client to sort of assess what is their risk tolerance and what are some ways to minimize that risk, and then make a decision based on that. So here we're talking about risk. You're serving as a risk manager. What are ways to minimize risk? Sometimes that's what we do. We can't really eliminate risk because everyone makes their own decisions. You can only control so much, and so it's an important study. And I think this discussion question is really important because it helps you think about, okay, I can't control everything, but what are some ways to minimize risk? And so that's a good way to think about it. Just a few things from the text I want to talk about as we move forward through this material. Of course, not all the material in the text we're going to be able to cover through our assignments and through our discussion questions. So I want to take the opportunity in these videos to cover that just for in the name of being comprehensive. First thing, let's talk about physician duties, physician professional responsibilities. So many of you are practitioners, licensed practitioners, and you know that physicians, like all licensed practitioners, are governed by some sort of state board of health or medicine. Every state has statutes and regulations that govern licensed practitioners, governs what constitutes unprofessional conduct, and when a physician or other licensed practitioner can be disciplined. And that discipline can come in a variety of ways. It can come through censure, through suspension, through revocation of your license, through educational requirements. I've been involved in only 2 physician disciplinary cases, and while they always make for the most interesting stories, some takeaways from those 2 cases, at least that I was involved in, is be totally honest with your patients and their families, and don't mess up, don't falsify medical records. I mean simple things like that I know for you and me seem to be common sense, but isn't the case for everyone. In your text you're reading for this week, it talks a little bit about patient dumping, the duty to treat indigent patients, and we talked a little bit in that first or second week, about EMTALA, the Emergency Medical Treatment and Active Labor Act, which imposes certain obligations on emergency departments to provide a medical screening and stabilizing treatment. So the question then becomes, what is an emergency department? Of course, there's a lot of case law on this, and of course, this is what lawyers do. We try to find loopholes and definitions. What is and what isn't an emergency department? What is a stabilizing treatment? What is a meaningful screening for patients who come into the emergency department? There's a lot of federal rules, a lot of guidance, a lot of case law on this question, and really this kind of is, to me, is a perfect example of that confluence of ethics and legal issues in healthcare, where as a society we have collectively decided that we have a moral obligation or an ethical obligation to treat people who have emergency medical situations, regardless of their insurance status, regardless of their financial situation, and then that has been codified into a law. And so and to me, EMTALA represents is a good example of that. Your text talks a little bit about patient abandonment. Patient abandonment is really just a form of negligence, and it occurs when a physician terminates that doctor-patient relationship without reasonable notice, and really fails to provide the patient with an opportunity to find a qualified replacement. Now, sometimes this isn't an issue. It depends on the health situation of the patient, right? So if the patient's right in the middle of a critical health situation, maybe that reasonable notice looks a little bit different, or the need to find a suitable replacement looks a little bit different, as opposed to someone who's not really going through any medical emergency or has any major health issues. So generally, this is a state law issue, so every state really defines it a little bit differently. But generally, there are 5 elements, and you'll find they're very similar to our elements in a negligence case. The first is healthcare treatment was unreasonably discontinued. The termination of the healthcare was contrary to the patient's will or without the patient's knowledge. The healthcare provider failed to arrange for care by another appropriate skilled healthcare provider. Healthcare provider should have reasonably foreseen that harm to the patient would arise, and that there was actually harm or damages to the patient. And so really, it's in essence, it's sort of a negligence case, but that occurs when a physician terminates that relationship. Here's some examples, some actions that have led in certain case law to a liability for a patient abandonment. Premature discharge of the patient by the physician, failure of the physician to provide proper instructions before discharge, refusing to respond to calls or further attend the patient, leaving the patient after surgery, or failing to follow up on post-surgical care. So these are all just examples of where different courts have found there to be patient abandonment. Of course, they analyze that within the confines of those elements I described. Finally, I want to talk a little bit about privacy. We're going to get more into medical records next week, and your discussion question for week 4, which is my favorite discussion question of the class, has to deal with an analysis of a privacy issue. So remember, privacy, HIPAA generally prohibits use and disclosure of protected health information unless an exception applies. There are very few mandatory uses or disclosures of PHI. Those that are mandatory generally have to do with patients' rights. HIPAA is really into patient rights. Patient right to access, patient right to amend, patient right to disclose an accounting of uses and disclosures. Those are mandatory. The healthcare provider also has a lot of permissive exceptions to that rule. Things like they can use or disclose PHI, protected health information, PHI, for treatment purposes. Obviously, if a provider, if 2 different providers are collaborating on the care of a particular patient, a mutual patient, they can disclose PHI for purposes of that treatment. Payment, I mean, clearly a provider can disclose protected health information, service dates, the procedures that were performed, and whatever information may need to justify medical necessity of that procedure to an insurance company, to a payer, for purposes of payment. And healthcare operations, which is a fairly broad definition, but internal quality assurance, just internal provider operations is a permissive exception. So there are others like subpoenas and criminal activity and just a variety of other permissive exceptions. But the key is those are permissive, so they aren't mandatory. A provider doesn't necessarily have to disclose in those situations, disclose PHI or use PHI. Really, the mandatory disclosure and use requirements pertain to, like I said, patient rights or court order. If a court orders it, then that's also mandatory. I'm going to post great resources. If you ever have a question about HIPAA, privacy, security, great resource is actually the Department of Health and Human Service website. They have great FAQs. They have a great search function. They have a lot of great information on there. I'm going to post the link in the announcement, but you'll also see all the penalties that are assessed by the OCR. It's the Office of Civil Rights, which is the arm of the Department of Health and Human Services that enforces HIPAA. And the key is, I think I mentioned this, maybe I didn't, to somebody, but the key, one key thing to remember is that HIPAA does not provide a private right of action for anyone. If your information is breached, if it was improperly used or disclosed, you don't necessarily have the right to go sue the healthcare provider for that improper use or disclosure. HIPAA doesn't provide that. Now you can make a complaint to the OCR, and they will open an investigation, and if the outcome of the investigation is not favorable to the provider, then they may be sanctioned. They may be assessed penalties, but you don't necessarily take part in that. You don't get any money out of that. Now, some state laws do have privacy. Some states have privacy laws that do allow patients to sue and to get damages. California is an example of that. And then some states have their attorney general of the state may open investigation and assess further penalties and sanctions. So anyways, that's all I have today. We're going to talk about more about privacy this coming week. I just want to sort of tee it up today to get you started to think about it. Again, if you have any questions, if you have any comments, anything at all, if you need anything, please feel free to reach out to me. And I hope you have a great week. Looking forward to another week of great engagement. Have a good one.